Hello, everyone, and welcome to my show. Autumn is here. I'm Francine Crawford, your host. Today, we are here with Audra Barrow, who is an estate planner and an Medicaid planning attorney. She's here to give us some information on how to help us in dealing with our parents and our aging parents and the things that comes up. So please welcome her to the show. Welcome, Audra. How are you?
I am fine, and I would like to start by telling you thank you, Ms. Crawford, for inviting me to your show to speak on an area that I'm so passionate about, which is estate and Medicaid planning. To the extent that you have questions about that, I'd like to tell you a little bit about myself. As you stated, my name is Audra Barrow, and I am an attorney, and I'm the visionary of Barrow Law Group. Barrow Law Group is a boutique firm located in Brooklyn, New York, which services all of New York State. We offer both in-person and virtual consultations. Okay.
Awesome.
And I have been practicing, I forgot to say that, for right now it's about 28 years in this area.
Okay. Awesome. Okay, well, you know that my show is about getting people more involved with their parents and their aging parents. And many times people become the caregiver of their parent, but they are thinking about the medical aspect and not thinking about the business aspect and they're emotional and they can't make the, decisions without proper help. So I just want to ask you some questions and you can come right in with anything that you think we need. But as far as when people are caregiving and they're taking care of their parent, and they need to be able to have access to their parents' business, is there any specific documents and things that we need to know about that we can put in place before a crisis happens?
Absolutely. So very often people wait too long. So it's very important that a person do what I like to call horizontal planning rather than vertical planning. And that is where we create at least a power of attorney, health and healthcare proxy. The power of attorney is the tool that allows you, the person that is having it created for them, to name a person to make their legal and financial decisions. And this is extremely important. It doesn't matter what your relationship is to a person. It is important that that person have a power of attorney in place. The power of attorney allows you to make decisions on their behalf. So it could be your parent, spouse, sibling, brother. It doesn't matter what the familiar relationship is. Without that power of attorney, you cannot make decisions for them. And it may end up with a guardianship. And that's what I'm seeing so often in my firm. And it's heartbreaking for me to have to advise a person that they need to seek guardianship for their loved ones because the power of attorney was not created in a timely manner. That power of attorney must be created while a person has mental capacity to answer questions and of an attorney that is drafting the power of attorney. And just as a little footnote, I want to tell people that the power of attorney is not something you should try to create without an estate planner because the power of attorney just will not be robust enough. So it's not something you download. It's not something you create from LegalZoom. It's not something you even go to a general practitioner and a general attorney for, because they're going to create a power of attorney that will not take in mind everything that needs to be considered about elder law and incapacity. That is a specialized area of law. And for that, you need an estate planner or an elder law attorney, such as myself.
Okay. Wow, that's interesting. And healthcare proxy, what exactly is that?
So the healthcare proxy, most people think that a healthcare proxy is a medical form that is given to you by a hospital or when you go for an outpatient procedure. But the healthcare proxy is actually a legal document. It is a tool that someone should definitely have in their toolkit, and it nominates a person to make your medical decisions for you when you're unable to make them for yourself. So you haven't relinquished your right to make decisions, but you're making medical decisions. A person is making medical decisions for someone who does not have the ability to make them for themselves.
Okay, okay. People are always asking about the difference between a will and a living will. How does that come into place?
Okay. So most a will, meaning last will and testament,
Mhm.
is a tool that is ineffective. It's totally ineffective until a person dies. Whereas a living will is a tool that is effective during your lifetime. So both the living will and the power of attorney are only effective during a person's lifetime, and they are no longer effective after their passing. And the living will basically tells your family or any and all medical staff attending to you whether or not you would like life support if you're ever terminally ill, permanently unconscious, or suffering irreversible brain damage. So that's the difference between the two. One is effective at the time of your passing. That's the will. And the will also, what the will does, I failed to say that. The will is you telling the courts basically who you want to inherit what you've left behind, as well as who you want to be in charge of gathering all those assets and distributing them at the time of your demise.
Okay, okay. It's good to know. So can we talk a little bit about trust? Because people have some confusion about a trust in relationships to a will.
Okay. When a person has a will, and that's the focus of their plan, they normally do not have a trust. So a person who just wants to set out what their wishes are for who should inherit their assets, and has a will created for them, they're basically saying to their family, at the time of my passing, you or loved ones receive X, Y, and Z. What most people don't realize is that wills generally require probate. And probate is a process in the surrogate's court in the county where that person resides. Now, as I stated earlier, I'm in New York State. And New York State's surrogate's court process for probating a will can be daunting for many people. Now, the trust, on the other hand, there are living trusts. I'm not speaking about testamentary trusts here. I'm speaking about living trust.
Okay.
Living trust also can convey property at the time of a person's passing. The major difference between the will and the trust, major differences are: one, a living trust is effective during a person's lifetime. So that means that during my lifetime, if I put assets in a trust and I ever become incapacitated, then the trust can name someone to carry on the duties because I'm incapacitated, or will name a trustee that will control the assets in the trust during the person's lifetime. Whereas, as I said earlier, the will is only effective at a person's passing. Also, the trust allows you to avoid probate. So trust, especially the trust created here at this firm, are self-administering, allowing you to avoid probate, avoid the courts. Your assets pass to the named beneficiaries outside of court. And also, some trusts also protect your assets. So this is a feature of a trust that is not even possible by way of will. So during your lifetime, you can have a trust created for you that will protect your assets so that the assets are more calculated to get to your family because they're protected from your creditors, as well as protected from Medicaid recovery. So that's another major difference between a will and here I'm speaking about an irrevocable trust.
An irrevocable trust.
Yeah.
Okay. Okay. Well, that's interesting that you said about Medicare recovery. So,
Medicaid.
Medicaid recovery. So, can we talk a little bit about that? I know that you said you're a Medicaid planner. So, can you give us a little bit more information about that?
Certainly. For people who do not plan, who do not create plans, or who have plans that consist of wills as opposed to a trust, and again, I'm speaking about an irrevocable trust, if they're ever in need of care, and I don't mean surgery or a medical procedure or going to the doctor, I'm speaking about care on a daily basis.
Mm.
They're ever in need of care on the daily basis to help with activities of daily living, for instance, transferring, bathing, feeding, dressing. So if they're ever in need of care for activities of daily living, then they need something called custodial or long term care. And Medicaid is one of the payers of long term care.
Mm.
And if a person qualifies for Medicaid and has assets that exceed the Medicaid limit, then at that person's passing, Medicaid can recover against those assets. And that is Medicaid recovery. Now, for that reason, it is often that people think to themselves, well, I can't qualify for Medicaid because I have assets.
Mhm.
And that's a myth that I hope to debunk here now.
Okay. Yeah.
You can qualify for Medicaid, and I'm speaking again Medicaid as a long-term care payee, and while having assets. So, for instance, if you have a home and you needed care, and you've done planning, what we call pre-planning, before the crisis occurs, and your home has been in a trust for 5 years, then you are 100%, your home is 100% protected from Medicaid recovery.
Mm.
If you need care in the home until the end of this year, you can place your home in an asset protection trust. And within 60 days, approximately 60 days after that date of placing your home in the asset protection trust, you can qualify for Medicaid. So, the one takeaway that I would like anyone listening here today to have is that I want people to realize that in New York State, I don't know the nuances for other states, but in New York State, you can own assets and still qualify for Medicaid, so long as you've done the pre-planning.
That's interesting because I know a lot of people feel that way that they have assets, they have to get rid of the assets before they get on Medicaid, and then they're going to lose everything if they, go into a home or something like that. So people are very concerned about that. Some questions that have come to me. People were wondering. I know we talked about trust. They were wondering if they didn't own their house full out and they still had a mortgage, could they still put it in trust?
Oh, yes. According to the Garn-St. Germain Act, a property can be placed in a trust even though a person has a mortgage. However, there are some exceptions. If you have a reverse mortgage, you cannot place your property in a trust. It will trigger the due on payable clause, and the mortgage will be due immediately. So you cannot place your property in a trust if it is encumbered by a reverse mortgage. Also, there are some investment properties that specifically the mortgagee will state in the note or in the mortgage that the property cannot be placed in a trust and is monitored. So for those properties, no. But generally speaking, you can place your property in a trust, even though it is encumbered by a mortgage.
Okay, okay. And just to be clear, because some people think that you get a trust only if you have a home. Can you tell us other things and other valuables that we should put in trust?
Absolutely. So I'm so glad you asked that question because that is the thought that trusts are only for homeowners, but trust is for anyone who has anything of value.
Mhm.
So one, again, there are trusts that allow you to avoid probate and avoid guardianship. And maybe you have assets. Again, assets are anything of value. You might have assets that you want to make certain that you're able to protect them. And so you may place those assets in a trust, or you may have assets that you want to make certain that your family always has access to, or someone who you choose has access to in the event you become incapacitated, as well as you want your family to avoid probate. So assets that can go into a trust are a bank account,
Hmm.
an annuity. You can put your a business in a trust. You can put a brokerage account in a trust.
Hmm.
You can make the trust the beneficiary of assets so that the assets at the time of your passing would go directly into the trust with your instructions tied to them as opposed to just giving them outright. And your instruction may simply be that you wanted it in a trust where the person would have asset protection. And very often people overlook that, the benefits of putting an asset in a trust for even for the beneficiary's purposes. So just different, almost every asset can go into a trust except for assets that have to be owned by an individual. And in New York State specifically, retirement assets are protected once they are retirement assets that are considered qualified. And the average retirement asset that is qualified is a an asset that a retirement asset that you obtain through your employment. But let's say you have assets that you annuity or you have retirement accounts that you created and that are unqualified. You created them yourselves. They can definitely go into a trust. Your life insurance, whole life insurance can be placed into a trust. And if you think you have retirement assets and you're at a particular age that you're over 59 and a half, because that's the age where if you draw from the retirement assets, you will not be penalized. 59 and a half and older, you're not penalized. If you think you're not going to use those retirement assets, you have sufficient funds to live off of with your any other income that you have, then you can place the retirement assets in the trust over time so that those assets would be protected.
Okay. Okay. All right. So that's good. That's good information because it's not limited just to a house. So
Absolutely
that,
not.
yeah. So that's great. So can I ask you again about a little bit about Medicaid? Are there anything that you would like to say to people that would help them deal with the frustration of Medicaid and trying to get it because people don't understand Medicaid, Medicare, and things like that. But people have gone down and tried to fill out forms and things like that, and they've been frustrated. Is there anything to clear up that they need to do first, or that they need to make sure they have certain information, or whatever that you can do to help that situation?
Um, to be very honest with you, I think that's actually where the Medicaid planning or elder law attorney comes in. Medicaid rules are not something that the average person knows. And each person presents with a different set of facts, meaning you may have certain assets that you hold and you may hold them certain ways, and you may have joint assets and you may have a spouse, or some clients come and they're single. So it is extremely important that you choose an attorney who is going to preserve your assets. And that's one of the most important things. It's not just qualifying for Medicaid that's important. It's qualifying for Medicaid and coming up with a a plan that will preserve the most assets. So a good estate planner or elder law attorney is going to create a plan or strategy for you where you not only will qualify for Medicaid, but preserve as much assets as possible in the process of qualifying.
Okay. Okay. Well, thank you for that. Thank you. Is there anything else that you would like to say to the audience that would, help, or things that you know that are frequent mistakes or things that people, may need to know?
I'm going to say this because of the audience that I believe that you're reaching out to. Very often I realize people are not realizing that loved ones are losing capacity until it's too late. And I think this situation was really highlighted by the piece that was done on Wendy Williams. But to make a long story short, the family didn't realize that she was losing mental capacity and she needed help. And finally, the court had to appoint a guardian for her. And a lot of people think that that guardianship is something that only happens to wealthy people.
Mm-hmm.
But guardianship is an everyday proceeding in a court in every county in the state of New York and in every state in the United States.
Mm-hmm.
It happens to the regular person.
Mm-hmm.
And so I want everyone to realize, one, the importance, if nothing else, the importance of a power of attorney. So from the time a person becomes 18 years old, they can have a power of attorney drafted for them. And that power of attorney, once drafted, again, not something you download, something definitely drafted by an estate planner, will give someone the authority to make your financial and legal decisions and can allow you to avoid guardianship. It's not as great as the trust are to avoid guardianship, but it is a tool that can prevent the guardianship. But it has to be done when your capacity is not in question.
Mm-hmm.
So what I'm saying to everyone is do it early.
Mm-hmm.
Do it when you're healthy. Do that planning when nothing is at issue, so that it's less likely that it can be challenged.
Right. Exactly.
So, yes.
That does come up. A lot of people talk to me about their parent has dementia and then they want to go start the paperwork and things like that. And it's like, well, if the doctor has already said that your parent has dementia, you may not be able to go forward with certain things.
Right.
And a question on power of attorney, how long is that as far as like, do you have to do it every year?
No. So there are different types of power of attorneys in New York State, but I noticed that the profession is shifting more to just the durable power of attorney as opposed to what is known as a springing power of attorney. And that durable power of attorney is effective for throughout the person's life. And so unless they revoke it.
Mm-hmm.
So it's effective throughout the person's life and even in the person's incapacity. And it becomes void, or it's no longer effective once the person dies. So I often see people wanting to go to the bank at a person's demise, or wanting to go to different institutions to act on a person's behalf, and that person is deceased. You cannot. Once the person is passed away, you can no longer act on their behalf. So it is an agency relationship that requires the principal to be alive.
Okay.
The agent is the person they nominate, but the principal must be alive because the power of attorney actually says that the agent is acting on behalf of the principal, the person who gave them the power. So once that person is deceased, you cannot act on their behalf.
Right. Okay. 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 Great. Great. Well, thank you so much for taking the time to share information with Autumn here. And I'm sure people will be helped. These are some questions that have been people were asking and people are interested in. And we just need to know more before something happens, before a crisis happens, and just start these conversations with our family members now.
Yeah, I think pre-planning is essential.
Yes.
The firm Barrow Law Group offers a workshop every other week. So people can either call our office at 718-763-1010. Again, it's 718-763-1010 to get the information for the workshop. Or if you're computer savvy, you can go right to our website, which is Barrow, Barrow, lawgroup.com. And we have a workshop page, and you can just register for the workshop. It is free. So the workshops are free. There is nothing more important than an informed decision.
Yes. Okay. Thank you so much. I really appreciate you taking the time and giving us this information.
Absolutely.
And I'll definitely look into this and look into the workshop and things like that also. So
Okay.
again. All right.
Thank you. Thank you for having me.
All right. Thanks.
All
Bye-bye.
right. Bye-bye.